How long will Ripple's lawsuit against the SEC last? Which new Ripple partner will be able to influence the situation in court? We will answer these questions in today's video. David Schwartz, Ecto of Ripple, has become a Twitter sensation. The Ripple executive and XRP ledger developer made a remark about urinating in a pool in a tweet yesterday, prompting the reaction. Schwartz writes, "I was informed that as long as nobody is really near to you in a pool full of people, nobody would know that you did. I see now that this holds true only if you are in the pool." The crypto and XRP communities have responded in droves to the humorous tweet. It has been speculated by a few Twitter users that the Ripple executive's message may have some hidden significance. As a result, there have been attempts to establish connections to sources of liquidity. Unfortunately, there seem to be no such obvious links. Note that, as was previously reported, XRP ledger engineers are now testing a native automated market maker, AM. Schwartz claims the AM's features, such as facilitating single-side liquidity provision, set it apart from other similar products. In contrast, those who found the joke funny but who didn't interpret any deeper significance posted anecdotes and memes as responses. Even yet, it's worth noting that the tweet has earned praise from an unlikely source, Cardano creator Charles Hoskinson. We should also note that Hoskinson's relationship with the XRP is tense. Notably, he has been at conflict with the community in the past due to remarks he made about the purported settlement date for Ripple and comments he made regarding the links between officials at the U.S. Securities and Exchange Commission and Ethereum. Due to the poisonous and petty nature of the XRP community, Hoskinson said in December that he would no longer be making any more comments on the subject. Furthermore, he said that he had no qualms about severing ties with the community since XRP had no technical or business value. Recently, Ripple to David Schwartz and Bitcoin advocate Tuur Demeester had a Twitter debate over whether or not Ethereum IOU was superior than Microsoft and Swift shares. Demeester sparked the discussion with a tweet regarding the Howey test, a legal standard for determining whether or not a certain investment becomes a security. Demeester argued that ETH passes the Howey test because it is a pooled investment in which the returns depend on the efforts of others. "I don't understand what you're saying precisely," Schwartz said. "You're claiming that ETH represents a joint financial investment in a shared venture. They got their ETH straight from ETH, you say?" Eleanor Terrett, a Fox Business journalist, predicts a major SEC announcement tomorrow. Ripple's CSIC case is nearly finished. Everything has been briefed, according to attorney James K. Filon and Judge Annalisa Torres will make the decision. Before the court ruling, attorney John E. Deaton, who represents thousands of XRP holders as a friend of the court, recently argued that an out-of-court settlement is unlikely. Following the Lelbrie decision and the FX collapse, the lawyer believed the regulator would fight to the bitter end. As a result, he anticipates a settlement only after a court stays a jury trial and hears appeals. However, since the attorney made this prediction, the Lelbrie case has changed. After supporting Naomi Brockwell's motion to limit the SEC's remedies, the judge clarified his ruling that Lelbrie credit sales were securities and did not apply to secondary market sales, according to the attorney. According to the attorney, the judge forced the SEC to admit that investment contract assets are not securities. As we await the court's decision, Ripple's general counsel compared the SEC's case to the Chinese spy balloon shot down by the U.S. military. This is something Terrett suggests. It comes after Bloomberg reported that the top cryptocurrency exchange is being investigated by the SEC for selling unregistered securities to Americans. According to unnamed sources, the investigation is nearing completion and a settlement may be reached in the coming days. Kraken is the third largest spot crypto exchange, according to CoinMarketCap, with $629 million traded in the last 24 hours. It provides 221 different cryptocurrencies. The report does not specify which of these are considered securities by the U.S. market regulator. The views of the SEC chair on cryptocurrencies explain the reported SEC claims. Gary Gensler believes that, with the exception of Bitcoin, most cryptocurrencies are securities. The SEC charged Gemini and Genesis Trading earlier this year with offering and selling unregistered securities through Gemini's Earn program. On February 8 at 11 p.m., UTSA Coinbase CEO Brian Armstrong tweeted that he had heard rumors that the SEC would prohibit retail investors from staking cryptocurrency. If true, Coinbase's CEO believes it will be detrimental to the United States. Running blockchains with users, according to Armstrong, improves scalability, security, and carbon footprint. Armstrong also asserts that staking is risky. The CEO of Coinbase has once again called for clear crypto rules to avoid suffocating us technology. Armstrong argued that the SEC's enforcement only approach drives businesses overseas, citing the failure of facts. Staking compensates users for securing crypto assets in order to validate blockchain transactions. Cardano allows for non-custodial liquid staking without tying up funds. The SEC considers cryptocurrency a stake in its jurisdiction. According to Gensler, Ethereum's transition to POS could make it a security. Staking is charged by cryptocurrency exchanges. In January, Coinbase was the second most popular Ethereum network staking service with 12.8 of 16 ETH staked. As a result, prohibiting retail staking could harm the company's revenue. The SEC is also looking into Coinbase for selling unregistered securities to customers in the United States. According to the SEC's insider trading case against a former Coinbase project manager and 2 others, 9 of Coinbase's cryptocurrencies are securities. If the SEC prohibits retail crypto staking, investors may shift to less censored decentralized services like Lido. Publicity-hungry Twitter lawyer John Deaton recently boasted about getting the U.S. Securities and Exchange Commission, SEC, to declare on record that LBRY's LBC token is not a security. Many saw this as a hint that the big bad SEC had been put in its place for overreaching, and that Ripple, another business fighting the U.S. regulator over an alleged unlawful securities offering, may win. Deaton exaggerates, and XRP in any future crypto product will be unaffected. The SEC defeated LBRY months ago. A U.S. federal court concluded that LBRY's LBC token sale was an unregistered securities offering and unlawful. The SEC never called LBC a security. As Deaton notes, Howey cases are about whether the item was offered as an investment contract, not whether it was a security. Investment contracts are securities. LBRY and Ripple are SEC cases. Given that LBC's original sale was unlawful, may bag holders resell tokens on the secondary market? The SEC's proposed phrasing might ban LBRY's direct and secondary sales. The SEC seems unwilling to agree that any secondary market sale would not violate securities laws in court argument. Deaton entered. Naomi Rockwell, a crypto journalist, possesses 261,500 LBC tokens from the secondary market. No LBRY tokens were bought. As an amicus curiae, she asked the court if its LBC token ruling would restrict secondary market sale. Deaton represented her. If not, reject the SEC's wording. Deaton represented Rockwell in a remedies hearing last week. On his own program, Deaton pointed the judge to the widely distributed Lewis Cohen article, which examined 7 decades of securities case law and concluded that the asset underlying an investment contract has never been considered a security. Thus, any SEC order should not prevent LBC holders from selling tokens on the secondary market. Deaton claims he won many industry wins here. That's exaggerating. The SEC would have acknowledged that the pure situation of a wholly independent resale of tokens, the first selling of which was unlawful, is not a securities offering. The SEC never disagreed. Their legal documents confirm. The SEC has repeatedly said that the LBC token is not a security. Therefore, Deaton's on-record claim is meaningless. The SEC's hesitation to declare that no secondary sale constitutes a securities offering is justified. The LBRY case has always been about LBC token sales by LBRY, not secondary sale. The SEC may have submitted an unclear order, but as its documents show, it never intended to make any assertions regarding secondary sales as legality. The court asked the SEC about a simple transfer from one party to another, which the SEC properly recognized would not be a securities offering. However, this does not indicate that no secondary sale could ever be a securities offering, as Deaton claimed. Secondary sales may violate securities laws. Transaction type matters. The judgment does not affect the fact that LBRY's first offering was an unregistered securities transaction. That's why XRP is under fire, and the LBRY lawsuit won't impact Ripple's liabilities for its first XRP sale. Ripple officials pledged to develop secondary markets to boost the coin's price, which the SEC claims triggers the Howey test's expectation of profits depending on the actions of others prompt.